Welcome to the Eating at a Meeting podcast. I'm your host, Tracy Stuckrath, dietary needs expert, certified meetings manager, certified food protection manager. I have searched the globe to find people and businesses who are creating safe, sustainable, and inclusive food and beverage experiences for their employees, guests, and communities. In each episode, you will find authentic conversations about how food and beverage impacts inclusion, sustainability, culture, community, health, and wellness. I know that sounds like a lot, but we're going to cover it all. Are you ready to feed engagement, nourish inclusion, and bolster your bottom line? If so, let's go. Hey, everybody, and welcome to another episode of Eating at a Meeting. I am excited to bring to you live this conversation about a wrongful death lawsuit that has been filed in Florida for a woman who allegedly ate something and about 45 minutes, an hour later, passed away. And so I'm here with four attorneys that I know to talk about this. And the plaintiff is the husband of the woman who passed away. And then the defendants are Disney World, Disney Springs, and then the Raglan Road restaurant, which is where she ate. I want to bring to the show here, up on top here with me is Mary Vargas. She is an attorney who does nationwide impact litigation on behalf of individuals with disabilities, including those with food allergies, celiac disease, and non-gluten sensitivity. She's a founding partner at Stein & Vargas. And below me is Joshua Grimes, who is a leading meetings and events attorney based in Philadelphia. He is a noted speaker on legal issues relating to meetings and conventions. And then diagonally from me at the bottom is Ryan Gambala, who is an attorney with Dooley Gambala in Cleveland, Ohio. He chairs the firm's food and beverage industry practice and regularly consults issues involving legal liabilities of food allergens and represents those in the food service industry. Hello to the three of you.
Hello, Tracy. Good to be with you.
I'm glad that we're here. And everybody, I'm going to put this up here. This information in this broadcast does not serve as legal advice, even though I have three attorneys on here. We're not giving legal advice. And none of them represent any of the parties involved in this case. We're just here to discuss the case as it is presented so far. Correct? I got that right?
That's right.
You have it.
Okay, perfect. So given the competing claims in this case, you've got Disney World, which the restaurant sits on their property. We've got the restaurant, and then we've got the husband of the wife who died, the plaintiff. How would you assess the potential legal liability for Disney and Raglan Road in this case as it's presented? Anybody who wants to pipe in first?
Tracy, I think it's Ryan here. I think if you look at the allegations of the complaint and the answer, and again, they're just allegations subject to strict proof and, of course, evidence at trial. But in the answer, Disney concedes that the restaurant's located on property that it owns and leases to the Raglan folks. Now, the allegation from the plaintiff's side, from the estate, is that, in fact, Disney, by holding out some of the information related to this restaurant and its offerings as part of its Disney Springs destination, that the restaurant itself, that there's an agency relationship there, either that Raglan's an actual agent at Disney World or an apparent agent based on the way they hold themselves out publicly. And so I think that certainly is going to be the nature of the allegation from the plaintiffs and the way they try to tie in both Raglan and Disney. Now, will it be ultimately successful? We don't know. Certainly, the decedent was at the Raglan restaurant at the time that she consumed the food in question. But how far the agency relationship stretches to Disney will be an issue that I think everyone's going to be keeping a pretty close eye on.
If I might just add a few thoughts to what Ryan said. Yeah, and I looked at the Disney website in preparation for today, and it does have this restaurant listed at Disney Springs and has the menu of this restaurant. So I think there's some validity to the sense that this is a Disney restaurant, whether Disney is liable or not. You know, we have a legal saying, probably, probably everywhere in the country, join all claims and parties, and there's a lawsuit. So if someone feels that they're wronged, they're going to add Disney and Raglan Road and whoever else might be responsible and let the courts sort it out later. I suspect Disney has a contract with Raglan Road that makes Disney, as between the parties, not responsible and probably indemnified by Raglan Road if for anything that might happen. But we don't know that today. That would come out at trial. And even then, that doesn't necessarily excuse Disney from liability. It's just if there was a judgment, Disney may be protected.
So if I could just add to that, obviously I am a lawyer, but I'm also the parent of a child with food allergies. And so it's hard not to see this case through both lenses. And what I know through both lenses is that people with food allergies have been told to trust Disney. They've learned that Disney is a place where they can go and they can actually go on vacation. They can obviously still have their food allergies, but there will be places where they can eat safely. And so when that's not true, when there's an allergic reaction that happens at Disney, and I've certainly heard about these personally, that there's a reaction that's different from when you go to a place that you don't know if it's safe. You've been told Disney was safe. And obviously this was the worst case scenario. This is what every parent of a kid with a food allergy, this is their worst nightmare.
Yeah. Tracy, if I could maybe piggyback on that for a second, I'm sorry.
Yeah. No, please do.
I was going to add, because I think it maybe ties in the comments that Josh made and that Mary made. I think that one of the interesting things about the agency relationship here is that the allegation, at least from the plaintiffs, is that through the website, Disney and Raglan, working hand in glove, hold themselves out as a place where you can ask the chef and where they have people on staff trained to handle food allergies. And so that's raised in the complaint as an allegation to support the agency relationship between Disney and between Raglan Road. But I think to Mary's point and to Josh's earlier, I think that's going to create some significant issues, I think, for the defense in this case, trying to maybe overcome some of those allegations in light of what seems to be publicly available, even apparently to this day on the website, the Disney website.
Right. I mean. Yeah, I agree. And Josh, I want to tie it a little bit to our meetings industry, which you and I talked about yesterday, I believe, is that when it's, and I'm just going to, it's a hotel brand, right? And I'm going to throw this to a hotel. It's a hotel brand with that brand name on it, but it could be owned by Mary and managed by you. And when we're doing a contract, and granted, they didn't sign a contract to come into this restaurant, but in that case, this could be turned into that kind of seen as the same kind of similar thing. They're going to go after everybody.
Yeah, correct. And look, your average guest doesn't want to hear, it's not a Disney restaurant. It's another company you never heard of. People don't understand that. And I think in a real world sense, that makes sense. You go to a Marriott hotel, you don't want to hear, we just manage this restaurant. It's really owned by 1845 Lick LLC Corporation. Right. But again, this is a matter for the courts to decide who's responsible ultimately. And also, as between Raglan and Disney, I suspect there are contractual agreements as to responsibility, which may not bear on any ultimate judgment that the plaintiff gets here, but it bears on who's going to pay it. If there isn't judgment, who's going to pay it?
I want to come back to your statement. You're a mother of a child with food allergies, and you try, or you help protect people with food allergies in cases that they're filing. And I know that you do a lot of cases that will make change. You're not doing it just for the sake of putting that case out there. You want to make change. How, to me, because it is Disney, this is a case that will potentially make change in the disability side of the world. Do you agree with that?
It remains to be seen. Obviously, we're very early in the litigation, and yes, what happens in the litigation will dictate the lessons that everybody takes from it. I think it's been very interesting how the public perception of this case has been. Very often in food allergy litigation, there's a hostile reaction, frankly, to people with food allergies who file lawsuits. And we deal with that in all the cases we litigate. You're just out for money. Why are you coming after us? Reality, I've never had a client who comes to me because of the money. They don't want it to happen to someone else. They want to be heard. They want to feel like they have some control and power and ability to make change when something awful has happened. And so it's been interesting to see in this case. And I think My personal opinion is it's largely because of Disney's fumbling of the defense that the public reaction has been very different. And that may also be because this is worst case scenario. This isn't somebody who had an anaphylactic reaction and survived a scary experience. This is somebody who died. And so seeing the public respond kind of with revulsion, like a collective gasp to Disney saying, you signed up for Disney Plus, so it's not our problem. I think that was a public perception misstep, along with, I would say, a few other kinds of missteps. But it seems to have shaped the public response to this case. And we all know that there are certain landmark cases that have that kind of public response that remain in the public memory. And I'm thinking of the McDonald's hot coffee case, fundamentally misperceived by the public in ways that for years after has caused the public to react to those kinds of lawsuits in a certain way. And I think there's the potential that Disney's, what I would say, misstep in saying we're not responsible that somebody died because you got a free trial of Disney Plus, that comes across as very cold. And the public had a very, I think, appropriately negative reaction to that. I'm letting my bias show. But that may have a long-lasting impact on how the public with food allergies is perceived. And the fact that here we have someone who, according to the complaint, asked all the right questions. They went to a place they thought they could trust. They asked all the right questions. They confirmed and reconfirmed according to the complaint. And then they died. And it may, in some sense, be a turning point in how responsibilities and consequences the people with food allergies are viewed.
I agree. And that I'm thinking like the McDonald's and the coffee, you said it all, right? It is how we're perceiving it. And I did it in April. They brought back, hey, we're the landlord. And then in May or June, they said, hey, they signed up for the Disney Plus. So it has been a couple of blunders in my mind as well. But I do think, them stepping back on that and allowing it to go to course potentially could have impact across the board. And I want to bring that into Ryan, because you work in the food service side of the business as well. The food labeling, or FSMA, right? Food Safety and Modernization Act, requires restaurants that have more than 20 locations and have standard menus to disclose the allergens and disclose the ingredients and the dietary needs. But Raglan Road is not one of those restaurants because they don't have that. So how will that play into this at all?
Look, I think the way, a lot of the legislation surrounding FSMA is related to food production and import-export and some things that don't necessarily directly trickle down to ready-to-eat service in a restaurant setting. I think, though, that what FSMA does is it puts into the public conscious and also into the food business conscience the notion that we have to have standards. There has to be a set of standards. This is I'm sure Mary could tell you, is a place of public accommodation. And when I think of FSMA legislation and food safety acts in various states and even other kinds of local regulatory codes and that kind of stuff, Tracy, what we're looking for is a set of standards. If you look at some of the legal arguments before Disney withdrew its motion to compel arbitration, its request for arbitration, there was a whole lot of stuff going on there in terms of who actually signed up for the Disney Plus account, an individual versus the estate, whether the clause applied beyond Disney Plus to other Disney operations, what the controlling law was, conflicting provisions on various platforms that Disney runs, and all the rest of it. Those were at least allegations before Disney withdrew the request. But I think the perception that Mary correctly pointed out was that Disney was trying to distance itself from this, was trying to get out from under this, was trying to not be a part of this claim or not be held accountable. And I think the optics of that are something that they're going to have to overcome going forward.
Definitely. Josh, how do we, coming from a hospitality perspective, how do we take these negligence claims or to the meeting side of this? How, if this was an event and not just two people eating there, how can a meeting planner and the attendee of that event or that meeting organizer look at this case?
The case is an eye-opener for making everyone responsible in the chain of running a meeting understand that they have a role to play. Because if this were to have happened in the context of a meeting, or a convention or event, then if someone were to be injured or die, they're going to look to the host organization and possibly the meeting planner, if they're a third-party independent planner, as well as the restaurant and as well as the landlord, if you will, in the place of Disney, for responsibility. This is like other things with due diligence. I think that it's yet another question that some planners should consider asking or looking into when you're planning a meeting. Do you have confidence that the hotel or the caterer will be responsive to needs of people with allergies? The same, no different than people who need special meals for religious reasons and other reasons. Particularly if the caterer or the food service provider has a bad reputation, that should be a warning sign. Now, there's what the lawyers would do, and then there's what most people would do in the meeting profession. Do I think that most meeting planners are going to add yet another clause to their contracts, which many feel are already too long, to say, you agree that you're responsible for fulfilling needs of people with allergies and any bad effects? I think the bad effects could be covered in a indemnification clause that covers a lot of other things, but important to have that. Important for the planners to ask attendees, their guests, in advance if you have allergies that need to be accommodated or any other special needs that need to be accommodated. It's not the be-all and end-all, because if someone doesn't respond to that but shows up and has special needs, the restaurant, the food service provider should still be obligated to do their best to meet those needs, or certainly to tell them if they can't meet their needs so the person won't eat something unknowingly. But this is all wrapped up in liability. Important for planners, for meeting hosts, to get indemnifications from the food service providers so that if something bad happens, that they're going to be protected. But we're never going to eliminate these risks, because it all comes down to, you can get as many promises as you would like to get, or as the provider's willing to give you. But as in this example, it appears it comes down to the server on site. It comes down to the chef on site. And if they don't do their job as they're supposed to, which is an issue here, I guess, things happen. So indemnification and insurance are important to have.
Mary, I want to, because Teresa just piped this question in, is I understanding that dietary restrictions requirements are covered under the ADA. How does this come into play for this case? So I want to bring it back to, you and I have had multiple conversations about this, and this is a general consumer walking into a restaurant. It's not necessarily an event attendee or an employee of a company. How does the ADA come and be involved in this at all?
So this case doesn't include any ADA counts at all. It's not a discrimination complaint. But where I think there's potential intersection is how the industry responds to this lawsuit. I think there are a couple different ways it could go. There could be a very knee-jerk response of saying, we don't want this responsibility. We don't want to serve people who ask for accommodations to menu items based on their disabilities. That then becomes a disability discrimination issue from my perspective. And it's hard to give a cold, hard, fast answer for every circumstance. But as a general rule, I don't think a restaurant can say, we're not going to make any accommodations for people with food allergies. And I do see that on menus, certainly all the time. I see disclaimers on menus all the time saying, forget what we told you. There's always going to be a chance of anything being in your food. And I think, the ADA does require accommodation or modifications that are necessary because of disability, food allergy, celiac disease. These things can be qualified as disabilities under the ADA. What accommodations or modifications are required by law is going to depend on very specific circumstances. If somebody has a peanut allergy and they're going to a restaurant that's everything peanut and all their menu items contain peanut and the place is massively cross-contaminated, the obligations are going to be different than if somebody is going to a local chain restaurant that serves general American fare, and they disclose that they have an allergy and ask for an accommodation that could be made. I would hope that the response is not the knee-jerk, potentially discriminatory response of we're just not going to serve you or we're just not going to make modifications. I would hope the lesson would be that we do need to make these modifications and we need to take it seriously. In the same way, when someone installs a ramp for a wheelchair into a restaurant, you don't install a crumbling ramp that can't hold the weight of the wheelchair that's supposed to pass across it. You need to take care and make sure that you're fulfilling the obligation to provide access, and that means to do it safely.
And to both of your points, I got an email last week saying a hotel's like, you have to tell us in advance what the allergens are, and otherwise we're not responsible for anything. And I'm like, yeah, no. I'm like, here's a different way to word it back to them. And they accepted that, like, we'll let you know, but you will modify your meals, to the best of your ability, right? Yeah.
If I might just interject, though, Tracy, what you just said, there's a difference between the hotel telling you, presumably in your capacity as a planner of some sort, in terms of the meal, that they're not that. And then there's what the guest knows when the guest is showing up to eat.
Yep.
And they could be too dear. And just because the hotel or the caterer says that to you doesn't mean that knowledge is automatically transmitted to the guest.
Yeah.
And from an ADA perspective, you can't contract away your legal obligations. So if an event planner is legally obligated to ensure an accessible event and they contract with XYZ Hotel to provide the food at the venue and they don't do it, they don't provide access, they say, you know what, you didn't tell us soon enough, so therefore we're not feeding you safely. I don't think that discharges the discrimination aspect of that situation.
I see that and understand that. Ryan, in our when we spoke back in May, and this is a quote that you said to me, and it comes back to knowing who knows the information, but you said once anybody on the team is aware of a condition, the whole team is deemed legally aware of that condition. So whether it's the hostess or that waiter, do you think that will play, and that they understand that to execute what I call the chain reaction to carry out that service? And I know from looking at the legal filings, the plaintiff has requested video and policies and procedures, et cetera, to manage all of that. Is that going to come into that? And that they understand that to execute what I call the chain reaction to carry out that service.
Okay. Got a little echo there. I would certainly expect it to. The chain reaction, we touched on it earlier as between Disney and Raglan, the notion of agency relationship. But what you and I were discussing this spring was the idea that for a food service entity, we act through our employees and through our agents. And so that's front of house. That's the host or hostess. That's the wait staff. It's the head chef. It's the cooks. It's the bussers. It's everybody. They're all agents of our restaurant. And so for purposes of the restaurant being on notice, say of a diner with a food allergy, I train folks that if one person on your staff is on notice, you as a whole, the restaurant itself is on notice. And so that's where the chain reaction comes in, Tracy. And the idea of the chain reaction is, for example, if a waiter, in this case, one of the allegations is that the waiter was notified of the food allergic condition for the decedent. So the chain reaction would mean, hey, if that information comes in, now we've got one person on our staff that's aware of it. How do we make the rest of the folks that are going to be involved in serving this guest aware so that we can handle things safely? And this is where your training kicks in. And so maybe it's a situation where the waiter goes to the head chef, who notifies the cook to get the allergen-free station set up, right? That would be our best practice, a dedicated allergen-free station with allergen-free utensils. Maybe it's not a dedicated station, but we get as far away as we can from everything else, and we use allergen-free utensils. But then the notification goes to the servers too, so that they know to keep an eye out for the plate that's marked allergen-free. In this case, I understand they used flags. Sometimes you see the purple ring or something else.
Yep.
Typically, we ask folks to get that stuff out of the kitchen as soon as it's ready, even though for an allergen-free table, maybe you would wait to serve everything all at the same time. to reduce the risk of cross contact, we would maybe want to get that out of the kitchen as quick as we can. So that's the chain reaction, is making sure that once somebody is on notice at your establishment, that the rest of the folks that are going to be involved in serving that guest are also on notice, because we don't want something to slip through the cracks just because of misinformation. And so that really comes back in large measure to me to training, because we have a certain turnover in the hospitality industry at a baseline post-COVID. I think everybody can agree, just this isn't me wearing my lawyer hat, but just as a consumer, that it's been even more challenging. And so keeping up on training, making sure folks understand what to do when a diner comes in and discloses a food allergy is important. And I think maybe to come back to something that Mary said, she had said, look, we hope the reaction from industry isn't, hey, we just can't do this, and so we're not going to serve you. And I certainly agree that I hope that's not the reaction. I think in today's climate, with the kind of the prevalence of food allergies, I think from a business perspective, I would want my clients to think long and hard about what it means to turn away everybody that has a food allergy and how that's going to impact the bottom line. And maybe a better way to address that would be to find some reasonable accommodations, which to her point is going to vary pretty wildly based on what you're serving, where, what the allergen conditions are, and so forth. But there is setting aside ADA, the Americans with Disabilities Act, just a general kind of negligence sort of standard. There is part of why I like having protocols in place and having chain reactions and having menu disclosures and redundant checks. Is there a menu disclosure at the bottom? Is there also an ingredient list? Do we have an icon, seeing the little shrimp or the little clamshell or the little peanut? Do we have waiters that affirmatively ask folks when they sit down, are there allergens at the table, food allergies at the table? Is because there is a reciprocal duty on patrons, right, to take reasonable care of their own safety. And so we have our duty to act reasonably on the restaurant side, and we have our duty to act reasonably as patrons. And so all of those steps and making sure that the people that are involved in the chain have that training, I think, is critically important. Because the risks, as this case illustrates, the stakes are high.
Yeah.
And I think to the extent that those, not just the training, but the policies and procedures are really well thought through and documented, is to everyone's benefit. It not only puts in the fail safes if waiter's having a bad day or a chef's having a bad day, that there are protections, that some restaurants have these policies. Only a manager will deliver the allergy order the customer. And to the extent, whatever those policies are, that customers are invited to be a part of understanding what the policies are. I think the scariest thing for somebody with food allergies to hear is an answer from when they ask if something is safe, if something has dairy in it, if they have a dairy allergy, and they get a response that's too easy. It's too, I know all the things, this is so simple. That's the answer as a parent that I don't trust. I would much rather have more information about, this is what we do. This is what the steps we take to make sure you know what's in your food and it doesn't include your allergens. And then the customer has the ability to assess that risk. When you go to a place like Disney that is understood by the food allergy community, rightly or wrongly, to be a place that they can go and be included and eat safely, when that's the impression, a place like Disney has a lot of work to do to make sure that they're living up to that impression, or that they're being clear what their goals and their policies, practices, and procedures actually are.
Right. Yeah. And it's been a long time that they've had that perception from this community. And whether it's Disney World or Epcot or Disneyland or Disney Springs, that perception from the food allergy community and celiac disease community is huge. And you can go online and find all kinds of stories and go eat here, and this is how you ask, and this is how great they do. So I do think it's a perception thing too.
If I could just interject a thought here, and I know my role is to help answer questions, not ask others questions, but I went on the Raglan Road restaurant website right before this, and I was going to just read their current statement, not to prove in this case, because I'm guessing they may have altered it since this incident happened. But it now says, and this is on the menu also, it says, for guests with food allergies, kindly note that we are not, in all caps not, a gluten allergy-free restaurant. We cannot all caps, guarantee that any dish we prepare is free from gluten, allergen, or free from cross-contact. Guests must notify their server of any allergy-friendly requests. A manager will discuss our allergy menu with you. Guests must use their own discretion to make informed choices based on their individual dietary needs. So that's what it says this morning. And I wonder if that kind of warning, and this is where, forgive me for asking a question, but does that vitiate or modify in any way sort of the faith that people have in Disney that everyone was just discussing? And I don't know the answer.
I don't think personally that it does. I think there are certain restaurant chains, certain venues in the United States that the food allergic community has historically been drawn to for a variety of reasons. There's this perception that they are going to be very accommodating for food allergies when they actually need to be. They need to do it safely. We've seen this with other fast food chains who have said things about the kinds of ingredients they use and that they're going to be whole foods and no hidden ingredients. And so the food allergy community, of course, is drawn to that because it's really hard to know what's in your food when you go to a restaurant and you're putting your trust in other people. So there are things that draw in the food allergy community, and that's wonderful. And it's for families, it's to have a place you can go is huge. It's hugely important. And there's a great degree of loyalty to those places who deliver on the promises that they've made. But I don't think that kind of warning on the bottom of a menu really changes anything in either direction.
When I hear a disclaimer like that, I think part of maybe, and again, I don't work with Raglan, I didn't write this, but I think part of what they may be trying to do is to highlight that reciprocal duty that I was just discussing on the diners, on the guests and the patrons themselves, to affirmatively come forward and let us know if you have an allergy condition so that we can figure out the best way to try and accommodate that safely.
And this is in Europe or in the UK. Somebody posted a statement similar to that, Josh. Somebody called up and asked, and she's got a legume allergy, and can I see the ingredients in what you're serving? And they're like, no, here's our allergen statement. You can go read this online, and just shut the person down. And I think that's a way to lose a lot of money. Like, we don't want the secret recipe. We just want to know what the ingredients are. And especially for those allergens that are not top 9 or top 14 when you're talking about the UK. And Raglan is not a chain restaurant that has 20 locations that are required to list their nutrition and allergen information in there. So it makes that a little bit harder for them. I say that maybe naively, for them to provide that information. Is that, yeah.
Sure.
Because I know in the UK they have different regulations around all of this too, and you could jump to Massachusetts, and I'm just going by a statement that I saw. They have a food allergy regulation in Massachusetts, and it says, please inform your servers if you have a food allergy before you order your food. But when you're at an event, and a restaurant's a little bit easier to do, but I've seen that sign on posters at events with 3,000 people, and we can't notify our server before we eat that food, right? I don't know where my question is and all that, but
I think that these kind of warnings and advisories are there, partly for legal liability and to get people to speak up if they have allergies, other things that have to be met, but also there may be some element of the public that if someone suffers an injury, maybe not a death, but some other lesser injury, that the restaurant, the first call is to the manager of the restaurant. They say, look at what's on the menu. And some people may not fight it anymore because they see that there was a warning there, an advisory. And that may be one reason, besides informational, why those things are on there. Just like when you go to the parking garage and they give, we're not liable for your car, for any injured damages to your car, which in most places is not worth the ink that warning is printed on, but people don't know that unless you know that. So just another theory on that.
I just don't know from the perspective of a person with food allergies or a parent of someone with food allergies. I don't feel that the way that particular warning is worded is helpful. There's a tone to it. first of all, that's not particularly welcoming. It's more like we don't want to be responsible.
Yeah, right.
I think there is a way to word that kind of information in a way that is useful and provokes a conversation that you want to happen between the customer and the server. And some of it's tone, some of it's letting people know to share the information. We will make the accommodations as we can, and we will let you know where accommodations can't be made for safety. I think a lot of it's about wording. The way that one reads is like the thing you read when you go skiing and they say it's dangerous. And if you get hurt, it's not our problem. And it is your problem, actually. And certainly I recognize this is different, but we had a lawsuit involving food in a venue that ended up going to one of the appellate courts. And one of the judges in a dissent in that appellate decision talked about foodborne illness in food. And restaurants obviously have an obligation to keep foodborne illnesses out of food. And I think where I hope we're headed is that allergens are viewed in the same way, that this is a sacred and important duty, and there needs to be free and full and open disclosure of the critical information from both sides so that everybody can make decisions about what can be done safely.
Bernard posted up here, we have way over 80 million, just the fact that you mentioned foodborne illness cases in this country every year. It's a lack of training and awareness the consumer is exposed to. We need much more proactive to face the danger of foodborne. On that note, but the food allergy training has to come into place. And I know that there's some states that have enacted stronger food allergy trainings. Not every state has it. And I know the food code has got some wording in there about labeling, but again, the food code is a guideline and not. Colleen also piped in here, if we see the Raglan Road statement in all restaurants and group contracts, why would a food allergic individual feel comfortable eating? It's a vicious cycle that excludes the food allergic community.
And you know what? If I may, that was my reaction to this. My reaction, and I will say, being as someone who does not have someone in my family who has allergies that they have to be concerned with this, so I'm not as familiar with that aspect of this as others. But I would read this to say, buyer beware. And if I'm not sure, based on my own experience, that there are things I can eat on this menu without being harmed, maybe I should choose another place to eat. And I'm not suggesting that's right, but I'm saying that's the way this reads to me, because they're basically saying you shouldn't trust us. And even if the server tells you something, take it for what it's worth. That at the end of the day, you make your own decisions. So I'm just saying I'm not saying that's right, but I think in some sense, that's what this is telling us. And this is maybe where we are with some restaurants.
I think in some sense, I totally hear what you're saying, but I think in some sense, those statements read to me, and this may be my mom ears rather than my lawyer ears, but it reads to me as water is wet. There's dirt on the ground. Of course, there are other allergens in a restaurant. When you go to a restaurant that's not a gluten-free, dedicated restaurant, of course there's gluten there. A statement that there's gluten there really tells me nothing. What I want to know, I want to have a conversation with you about what do you do to mitigate that risk? This is what we need. Are you able to do that? And I want a reasoned and considered response, not of just generally, there's gluten here, we can't help you, or there's gluten here, you decide. I want to know, what do you do that will make my meal safe or not?
Ryan, I'm going to come to you with a question in a second, but it reminds me of going to a hotel in Tampa and eating in their restaurant. And I said, I was asking about French fries. Do you have a dedicated fryer? And two different servers on two different occasions said, yeah, we do have a dedicated fryer, but it gets used a lot for all the other items. Right. And I'm like, so your training is, we don't. So why do you even say that you do have one, but it gets used for other things? Ryan, coming back from your perspective of really supporting and working with food service providers, that training is lacking in that situation. But how can we help these restaurants understand, hey, you can put down aluminum foil on a griddle and cook that person's steak so that it's not contaminated with the bread or whatever? Is that what we're looking at too?
I think in part, Tracy, I think it's a function. There's multiple components to safety, right? One is having policies in place that make sense. 2 is training on the policies. 3 is actually carrying them out in the heat of the moment. When I do trainings or when I'm talking to groups of people, I think it's in that setting, it's easy to think through what the safe course is. It's not always as simple when it's a busy dinner service, when you've got a lobby full, when you've got a bar area full, when every table's full, when people are flying around like crazy, when you've got 4 people that started that day, and when you've got other challenges just getting the service out. And that's why I say training is important, is because those are the times that you really need to be able to rely on your training, that you know what the policy is and you know how to implement it. So maybe the example that Mary gave, having a dedicated, or Tracy, maybe it was you, having a dedicated allergen free fryer is only helpful if it's only used with allergen free ingredients, right? If you've got standard ingredients in there, well, then in that case, you might as well use any fryer, right? And so somebody in that instance thought it was important enough to have a policy on that, but either the training or the practice wasn't carried all the way through. So either the individual that you chatted with was misinformed and then miscommunicated to the public, which is a problem, or the folks in the back who are actually using the fryer are using it the way that individual represented, in which case it sounds like there's a policy with implementing the policy. There's a problem with implementing the policy, which is this is a dedicated allergen-free only fryer. Look, I think you're absolutely right that those are going to be issues. I think to bring it back to this case, I think it's going to be interesting to see as the case develops what the evidence does show, because I do think, to Mary's point and Tracy's and maybe Josh's too, I think Disney is viewed by the public as a leader in some of these spaces. And I think it will be interesting to see what policies and so forth they do have in place and whether they were complied with in this instance.
One of the things I thought was very interesting about the complaint, and of course this is an allegation that has to be proved, so we'll see how it turns out, but there's an allegation in the complaint that this woman who passed away had allergies to both nuts and dairy, and that the cause of death was determined to be exposure to both nuts and dairy. So I thought that was surprising, that if that's correct, that this person was exposed to not just one of their allergens, but 2 of their allergens. How does that happen? That's a pretty profound fact from my perspective.
And elevated amounts, not minimal.
Mm-hmm.
Yeah. Again, the allegation is that she had self-administered epinephrine and that it wasn't enough. So that caught my eye too, Mary, and the fact that she was a physician, as I understand it anyways, in the allegation. And so a consumer that's reasonably sophisticated and you would think would be making sure to do some of the that we would hope for are most.
Okay, so to wrap this up, and I don't know how long it's going to take to go to court. I'm keeping an eye on it weekly, looking at the website and seeing what's submitted. I don't want to say, what do you hope to come out of this? Or is that the right question to ask? Or what do you see it going forward, just to wrap it up?
Ryan, please.
Well, I was going to say, from my perspective, I harp on about training and policy and procedure, but I hope to see an emphasis on having the policies in place, making sure they're complied with, and understanding how critical a component training on the policies is. You never want to be in a position where you've got an employee who at a deposition or on a witness stand says that he's never seen a particular policy or a particular policy manual. And so I'd be looking for some of those things to be highlighted and with her that maybe there was a mistake.
My heart really goes out to this family and all their loved ones. And I hope that whatever the outcome, there's some peace for them and that they feel that there's something that comes out of the litigation in this horrible situation. And I hope that the litigation process is gentle with them. They've suffered an unfathomable loss. And I think sometimes the courts are very harsh with people who are seeking justice in those circumstances, and the public as well can be harsh. And I hope that the public continues to recognize this fundamentally at the bottom of this case was a terrible loss.
Forgive me if my response, I agree with what Mary just said. In terms of my response would be a little more business-like.
I never have business.
And I say that at the risk of people seeing me as less empathetic, which I hope I wouldn't be seen. But to me, this is a putting people on notice who are involved with meetings, convention, groups, events, that you have to ask questions. It is, people have allergies, people are gluten-free, they have other health conditions, and it is more common that that these things are in society. People have the right to enjoy your meeting, event, conference, whatever. And if you're planning them, you need to ask the questions of the people who are preparing the food. You need to put means in place for making sure that those people can eat safely. And at the end of the day, again, if you're planning a meeting or a conference, you should allocate although everyone has some responsibility for making sure that food is served safely for your guests. At the end, there should be allocated responsibility by contract, including an indemnification if you're not the party preparing the food. And also, you should have insurance to cover the risk, because we hope nothing happens, but things sometimes do, as evidenced by what we're discussing today.
Yeah, I wholeheartedly agree. And Carolyn Browning pipes in another insightful topical conversation. Thanks, Carolyn. And Mary and Ryan, Chef Keith says hello to you, Norma. He was on Instagram. So
he's one of the comments. He's such a good egg.
He is, and he was actually leaving to go do a training. So
good. Glad to hear it.
Yeah. I'm glad he was able to listen to him. But I really appreciate it. I would love to have you all back after it goes to court and we find that happens, to discuss what the results of that court would be. Actually, Josh, Heather Reed just piped in. Should we ask for specific language, RE indemnification related to food preparation and service?
Sure. And I assume that Heather's asking that, or not just the Canadian answer to that question. The answer is you could be as specific as you want. The indemnification clauses, like everything else in meeting contracts, are getting longer and longer, but there's reason for that. And I think every meeting planner needs to assess their own risks in cooperation with their competent counsel who helps them put together their contracts.
Yeah.
Did I put that right?
I think so, because we're not giving legal advice here, but that was a very narrow term. Yeah, no, but thank you all very much. Margaret just piped in here. Thank you all on this panel. Very enlightening. Would also love to hear their thoughts on the United Airline pilot lawsuit at a later date, which is, I don't know if any of you have heard that lawsuit, but he is celiac and he was denied food that he could eat while working.
I'm the lawyer representing the plaintiff in that case.
Oh, you are? Okay. So let's talk about that later, Mary. Unless you want to mention something now, or you don't want to do that now, do you?
Not at the moment.
Yeah. Not at the moment. So yes. Okay. And Heather piped in, fabulous discussion. Thanks to all. Hopefully we'll come back in a couple of months and talk about what happened in the case, and we'll go from there. But thank you, everyone. I appreciate you.
Thank you, Tracy, for the opportunity to be a part of this panel. Thanks.
Yeah, you're welcome. Everybody, until next week, stay safe and eat well. Thanks.
Take care.
Thanks for listening to the Eating at a Meeting podcast, where every meal matters. I'm Tracy Stuckrath, your food and beverage inclusion expert. Call me and let's get started right now on creating safe and inclusive food and beverage experiences for your customers, your employees, and your communities. Share the podcast with your friends and colleagues at our Eating at a Meeting Facebook page and on all podcast platforms. To learn more about me and receive valuable information, go to tracystuckrath.com. And if you'd like more information on how to feed engagement, nourish inclusion, and bolster your bottom line, then visit eatingatameeting.com.